distinguished guests, colleagues, students. It's a great pleasure to welcome you to this year's Cyril Foster Lecture, which is entitled Gaza, the Humanisation of War and the Politics of International Law. The Cyril Foster Lecture was established in 1960 and is the university's principal annual guest lecture in the field of international relations. Since then, we've hosted many speakers from the world of politics and policy, from prime ministers and foreign ministers to secretary generals of the United Nations and heads of major international organisations, as well as prominent academics. It's an impressive list of the who's who in the world of international relations and politics. Sadly, though, we know very little about Cyril Foster himself, except that he lived and died in a caravan, and he owned several small shops in and around London. Yet international peace was so important to him that he left a significant bequest to this university, even though he had no connection to Oxford that we know of. And this bequest enabled the creation of this annual lecture series. The lecture series then reflects a long-standing commitment to the study and promotion of international peace and the better understanding of the nations of the world, an aim that remains as urgent today as at any point in our recent history. We are honoured this evening to welcome our distinguished speaker, Professor Samuel Moyn, the Kent Professor of Law and History at Yale University, where he also serves as head of the Grace Hopper College. Before I hand over to Professor Edward Keane to introduce our speaker, let me thank the Department of Politics and International Relations and all those involved in organising this event for continuing to sustain this important forum. Please join me now in welcoming Professor Keane.
Thank you. As the chair of the Cyril Foster Committee, it's my very great pleasure to welcome you all to this year's lecture, and especially to welcome our speaker, Professor Samuel Moyn, back to Oxford to give this lecture again, which he delivered once before over a decade ago. Of course, a decade is a long time in international politics. Since then, much has changed in the world, and Professor Moyn himself has continued to make new and significant contributions, notably in his powerful book, Humanisation, How the United States Abandoned Peace and Reinvented War, which was published 5 years ago. As I will come to in a moment, it's his argument in that book that will be the jumping-off point for today's lecture. As we just heard, Professor Moyn is the Kent Professor of Law and History at Yale University and the head of Grace Hopper College there. His original academic specialization was in history, getting his PhD at Berkeley and then joining the history faculty at Columbia University before moving to Harvard and eventually on to Yale. In addition to Humane, he has written a series of major books that is far too long to list in full here. It includes groundbreaking studies of ideas about human rights, such as The Last Utopia and Not Enough, major contributions to the history of political and international thought, such as Liberalism Against Itself, which was based on the Carlyle lectures he gave here at Oxford, and works on thinkers such as Emmanuel Levinas or Judith Sklar, and many others. As that suggests, he's an outstanding example of that much acclaimed but really rather rare thing in academia today, a genuinely interdisciplinary, or maybe that should be supradisciplinary scholar. While consistently informed by a historical sensibility, his work speaks to international relations scholars, political theorists, lawyers, philosophers, and people engaged in many other branches of inquiry. I gather that his most recent project is on aging in politics, exploring the effects of gerontocracy in the United States. I suspect that that particular theme might not feature so much in his lecture today, but it testifies to his extraordinary range of interests and expertise. As you've just heard, the purpose of the Cyril Foster Lectures is to consider the vital question of peace in our world. And I'm delighted that we have Professor Moyn here to speak to this topic, since he possesses one of the most original and thoughtful and thought-provoking voices on this subject in the academic community today. We live at a time when peace is often said to be precarious. There is much talk of how something called the liberal international order is under threat. There is a decline in support for the alliances and organisations that have played a key role in maintaining order in world politics since the Second World War, and new outbreaks of violence, including those that Professor Moyn will be discussing. History is often invoked in an attempt to help us make sense of what is happening now. For example, many seem to believe that we are witnessing a return to the great power politics of the 19th and early 20th century. Within this context, Professor Moyn has, throughout his career, developed an exceptionally penetrating, historically grounded, and often critical understanding of liberal projects of world ordering in the 20th and 21st centuries that challenges, or at least unsettles, many of the conventional wisdoms and pieties that we hear about the nature of the liberal international order, and avoids simple juxtapositions between the extremes of a warlike and amoral world of great power realpolitik on the one hand, and an idealistic international order promoting values of justice, human rights, and peace on the other. In his book, The Last Utopia, for example, he explored the historical roots of how human rights came to be a central part of liberal ideas about world order in the late 20th century, and showed how these were not expressions of some timeless or universal moral principles, nor the final triumphant realization of centuries' worth of Enlightenment reason, but arose specifically in the context of the failure of other kinds of world ordering projects in the late 1970s. Indeed, his previous lecture in this series was concentrated on the theme of historicizing cosmopolitan theories of global justice. Today, Professor Moyn will speak to another theme that animated his celebrated 2021 book, Humane, which is concerned with the profound reshaping of the relationship between law and war that has taken place in the context of the United States war on terror since 9/11. This is a topic with deep connections to the study of international relations here at Oxford, exemplified by current and former members of the university, such as Richard Kaplan, Yanina Dill, Sir Adam Roberts, or Jennifer Welsh, who have, of course, done extensive work themselves on questions about humanitarian war and humanitarian intervention. Professor Moyn's argument is that the United States' efforts to make the waging of war more humane by embedding it within laws governing armed conflict that reduce unnecessary suffering, or at least the perception of such suffering for certain constituencies, have tended not to end war, but rather to perpetuate it. His lecture today will explore what is happening now to this new configuration of law and war. A couple of very quick points before I ask Professor Moyn to take the stage. One is that there is no fire alarm test scheduled today, so if the alarm goes off, it is a real event. And we'd ask you please to leave by the nearest route, do not use the lifts, and the assembly point is on the corner of Merton Street. Secondly, as one might very properly expect for a lecture series that is devoted to questions about war and peace, there is bound to be much in this that will stir controversy and discussion. I would, however, ask people to hold any comments or questions until after the end of Professor Moyn's lecture, when we will have time for Q&A in the room here, before more opportunities for conversation over drinks afterwards. With that, it is with the very greatest pleasure that I invite Professor Moyn to give this year's Cyril Foster lecture.
Well, thank you very much. Oh, forgot about the doffing. Thank you very much, especially, of course, to Professor Keane for the invitation and the introduction, to the dignitaries, and of course to all of you for coming. Well, it was in another lifetime that I had the honor of giving the Foster Lecture some 13 years ago, and no one will disagree that we've all aged into a very different moment in international affairs in the last decade and a half. As Eddie mentioned last time, my theme was the liberal philosophy of cosmopolitan global justice, one of the illusions of the end of history, the apparent end, in which in my rebellious youth I specialized in at least attempting to smash. Nowadays, it's clear that the end of history is itself at an end. And I'd like to try to be more constructive. And so my topic today, though very narrow and very small, is about whether we can angle in the here and now for better outcomes amid horror. Now, this exercise will be a history of our collective response to events in our current moment, asking whether there were and are alternatives to where they've led so far. International law promises a bulwark against barbarism, or a better world, or both. Does it provide either, especially when we allow it to focus our attention on the inhumanity of violent warfare? It goes without saying that in the minds of millions, maybe more, Gaza, the place and the word, stands for that kind of inhumanity. That's in part the effect of new legal frameworks. And what I'd like to ask you to think about and discuss with you later is how those frameworks have altered our politics. So it was within days of the brutal Hamas attack on Israeli combatants and civilians on October 7th of 2023 that Israel's military response loomed. An evacuation order was issued October 13 to Palestinians in northern Gaza, where the Israeli Defense Forces entered October 27. In this ominous interval, in mid-October, the leaders of the United States and other transatlantic powers declared their fealty to Israel's cause, emphasizing its right to self-defense. These leaders observed in the same breath, almost, that if there were limits to that response, they were going to be in how the campaign ought to be waged, not whether the onslaught would come or when it should end were in play. The humanity of the enterprise is, these leaders said, what mattered, and the laws of war were mentioned. In a classic distinction from that domain, there were no jus ad bellum constraints on Israel to note. Its resort to force was justified, apparently without limits. There were, however, jus in bello rules, constraints on how it could conduct its hostilities. Now, if anything, American leaders were more consistent in this configuration, in this calm before the storm of violence. In opposition in this country, Keir Starmer, on an 11th October interview, you may recall on LBC, at first said Israel was within its rights to cut off electricity and water, but faced pushback for that statement, and then immediately clarified in a somewhat misleading moment in the House of Commons on October 23rd, that the right he had meant to assign Israel was merely that of self-defense. We stand with Israel and her right to defend herself against the terrorists of Hamas, he said. We stand, he added, for international law. Now, in this, these politicians, Joe Biden and Keir Starmer, followed easily the greatest contributor to the idea that liberal states may well have to fight unsought wars in their own defense. What mainly matters, therefore, is how they fight them. Barack Obama had pioneered, I think, this precise combination of a posture in which states must enjoy substantial latitude in their own self-defense, but in compensation, it is of the utmost importance that they avoid brutality, especially death and injury to civilians, and the resort to illicit tactics in fighting combatants, mistreating them, or at worst torturing them, if they are captured. Obama first offered this combination, if you're like me, old enough to recall, in an immortal Nobel Peace Prize lecture that he gave in 2009. And in 2023, that same month, October, he did so again in support of the policies of his former vice president. With you today, I'd like to put this combination in some historical and moral perspective based on some prior work of mine, as Eddie mentioned, but updating it, examining how it helped predetermine so much collective discourse about Israel's assault on Gaza and what we should say years later, although, of course, in an ongoing situation, about the politics of law in consequence. At the risk of frustrating you in my time, I will introduce no new facts. You know them all. Instead, the first half of the lecture will develop a framework of analysis, and the second half then turn to some different effects that I believe our collective focus, the collective focus of debates around Gaza on how humane the war was or wasn't exacted. Throughout, I'll try to compare the same effects to those in the war on terror, which first got me thinking about the attempt to humanize war, make it less brutal, and to turn to international law to perform that service, and how our conflicts in public debate about war have come to be reorganized in the spirit of those commitments. So, to review, the basic worry I voiced years ago, and one I learned has haunted the attempt to make war humane almost from the start of that endeavor, is that making a practice less brutal could have, for all of the good it does, collateral and undesirable effects. There could be a risk, and this risk presupposed a new moral agenda in human affairs, premised on the rejection of the form of ancient and much modern war. This risk dawned on observers already in the 19th century, though I believe the risk only began to be incurred in the 20th. Now, in this town, I've talked about the great explorer of the dilemmas of humanizing war. That was Count Leo Tolstoy. So allow me to pivot for today to his great successor at the turn of the 20th century, the Austrian noblewoman Bertha von Suttner. She scored a smash hit with her internationally best-selling attack on war called Die Waffen nieder in 1889. It was so famous that it was rumored that she would win the very first Nobel Prize for Peace in 1901. She, after all, had worked for Alfred Nobel and, at least on her own account, inspired the prize. 2 years before, she had attended the Hague Conference and was scandalized to witness what had begun as a peace negotiation devolved into the mere attempt to make war less brutal and costly. Now, she did end up winning her Nobel in 1905. Because of the delay, she was the second woman to win after Marie Curie won her first. And when the first Nobel Prizes were announced in 1901, Suttner flew into a fury. And it wasn't just because she didn't get it. The very first co-winner of the Peace Prize was one Henri Dunant, who was honored in his dotage for having launched the modern campaign to make the laws of war about reducing its brutality. He helped spark the very first Geneva Convention of 1864, which protected wounded soldiers. But the point of the prize, Suttner insisted, wasn't about making carnage less grisly and offensive. It was about mobilizing to keep war from breaking out in the first place or stopping it once it started, and so she flew into a fury, sought Dunant out, and begged him to come out as a friend of peace. Still, there's this great irony. Her anxieties that prettifying and sanitizing war would perpetuate it, and Tolstoy's before her and H.G. Wells's after her were too early. The main body of the laws of war, drafted by militaries or signed off on them, was not about making war humane in the first place. And the experience of World War I finally did lead states to prioritize a law and politics of peace, culminating in the United Nations Charter of 1945, faulty though it's always been. Suttner, I believe, was the great prophetess of that agenda. Well, that was then. In recent decades, I've argued, politicians, warriors, humanitarians, and millions of ordinary people have deprioritized not having wars in the name of precisely that expansive combination of self-defense with the demonstrative and heartfelt promises to keep the resulting wars cleaner, with which I began. It was no accident that Barack Obama, in that Nobel Peace Prize address, disavowed openly pacifist Martin Luther King Jr., and instead embraced and name-checked none other than Henri Dunant. He was the first president ever to mention his name. Well, before I turn to Gaza with this moral and legal framework in mind, I do need to pause to ward off or try to the objection that my approach to these questions is going to be morally obtuse or legally nihilistic or both. I know it will seem to some like I'm arguing about the fine points of cookery in the presence of the starving, literally. But it's always going to seem too early or too late to engage in the kind of analysis I'm going to try, which means that we may miss the chance ever to conduct it. So one way to put what I'm after today is in the terms of that Oxford philosopher who insisted that we care as much about what language does as about what it says. And so what I'm going to try to do with you is examine the performative force of international law claims, the range of the effects they have in our world, without getting hung up too much on the exercise, which is important, of whether the claims that people make on international law are constitutively true. In thinking about law, I want to insist we have to abandon the conventional and usually hypocritical pose that we all are tempted to take, which is that law consists basically of a body of rules that are obeyed or violated. Rather, I think we should regard law as a form of collective politics. And there's people in struggle over what the law means and what effects it's going to have. No disrespect is meant, but lawyers are not the best people to consult on this feature of their craft. Their philosophers acknowledge, including your Herbert Hart, that law can have areas of unclarity. But lawyers themselves enjoy no other power than the pretense that the political outcomes they seek are already commanded in the law, reducing the frequent ambiguities, conflicts, and gaps in rules to secure the relevance of the lawyers themselves, and allowing what they want to happen to be redescribed as what the law requires. Lawyers are going to be the last people to ask to divulge that their interpretations are political strategies, nor are they alone in our world. For many non-lawyers, too, find it opportune by choice or because they have no other option to advance their goals by saying the law already requires them. If we never ask openly, though, about what people are doing with the law prospectively and drop the lie that properly interpreting its meaning is involved, we don't obtain the distance to ask what matters. Is the strategy of pursuing goals through legalistic politics achieving its ends? Are there better strategies? Are there better ends? Now you will say, but doesn't the law clearly prohibit some things, some immorality? And isn't ignoring this fact obtuse? Actually, no. For the most part, the law licenses immorality, and certainly in addition to any morality it enacts. Nor is my framework nihilistic, I want to insist. It's not my fault that so many of our laws must have been made to be given their meaning in ongoing interpretive struggle. By accident or intention, rulemakers open the terrain of fighting on which legal strife proceeds. That's what we've lived through. That's what we constantly live through. That the meaning of the law can be resolved at times is no objection to this picture unless your suggestion is that the political strife that the laws prompted, the prohibition of genocide, whether it applies, what it means, was itself no factor in the resolution. Consensus is achieved all the time in the law, but not because it was already in there. Rather, one set of its interpreters prevailed on the terrain of struggle. So with that background, I should proceed to what has happened in our most recent round of political struggle around international law. If we apply this framework to the laws of war, so-called international humanitarian law, we can insist that certain things are or were clear in it. Without evasion or pretense, Hamas openly flouted the laws of war. The instigators of their crimes won't face accountability, not because they were innocent of the violations, but because Israel killed them. Israel, it's tempting to say, flouted the law just as clearly and almost as openly. And surely there has been some potentially large set of incontestable violations, but the whole question, isn't it, is just who controls interpretation and who sets the boundaries to legitimate interpretation of this or that legal norm, who distinguishes between what's clear and what's contestable. That dynamic, too, is one that we would miss as public debate rages over precisely these issues if we content ourselves with highlighting the clear violations, as important as those may be. And in the remaining zone of contestability, there were and always will be two sides, those doing permissive interpretation of the rules, those doing restrictive interpretation. It's clear that it's illegal to target non-combatants nowadays, but it's a matter for interpretive struggle just how much collateral damage is allowed, what harm counts as disproportionate to expected military advantage, and so forth. And the same is true for many other rules. And this basic divide between the more permissive and restrictive maps onto several other divides. David Luban, a great thinker, has said there are two cultures of international humanitarian law: a military community of practice, a humanitarian one, each with its own lawyers and outlets and websites and so forth. This divide between the permissive and restrictive also tends to track a divide between the global north and south, since when governments take positions, it's not as if each and all of them are unanimously on the side of permissive interpretations of the rules of war, at least when they're not fighting. It's long been true that the global south has pushed more restrictive interpretation than our countries, and it's long been true that the main force that they played in the making of modern international humanitarian law, after centuries of victimhood due to the imperial violence of northern actors, has been to strengthen it. So as a result of all this, I'm going to propose, just for my time, to avoid the easy exit from political analysis of saying that Israel just plainly violated the rules, engaging in what one excellent report dubs humanitarian camouflage, meaning Israel merely purported to follow the law but interpreted itself into compliance, because that's the point. Law is made to be interpreted. To the best of my knowledge, Hamas offered no legal apologetics for the October 7th attack, though there have been some moral apologetics for its acts. But it's of the essence, as Craig Jones and others have shown, that Israel in fact led the way in claiming to humanize the conduct of its forces through claiming to follow rules. If it was all just a lie, we would miss the point that the law is made not just to be broken, but interpreted. Excellent examples of this, which you'll know, include the rise of dual-use doctrines, which say you can strike at an otherwise prohibited target if it's being used by your military adversary, or alterations in rules of engagement in the shadow of international rules to allow compliance with proportionality rules while killing more civilians. Both have essentially defined the conduct of the Gaza war. So with all that background, I can finally turn to the second half of the lecture, which concerns how we assess the effects of the strife on the interpretive terrain of struggle, and not just the real one in Gaza. How did the regulation of this conflict by these international laws of the conduct of hostilities affect events? The debates about compliance and violation against a background that cruelty and warfare, especially if it slips into genocide, ranks high, or maybe at the top of our list of what's morally outrageous. I'm going to explore three categories of effects. The first, and perhaps most immediate, is the possibility that the law can help legitimate the war that it makes less brutal. Given enough convincing violation, it could have the opposite effect, sapping the legitimacy from the war or even the state that conducts it. The second effect is the classic concern of Suttner and Wells. War that we demand to be more humane could be rendered harder to contain, and in particular to end in virtue of our success. And the third, in which I'm most interested for today, concerns displacement or distraction, or in another vocabulary, opportunity cost. Where else could and should the focus of our moral attention have fallen or fall now, compared to a very understandable obsession with the inhumanity of the conduct of hostilities? So let's begin with the legitimation effect. And in this scenario, it's a fascinating concern because I believe something new happened. The laws of war in retrospect did legitimate the evolution of the war on terror, led by my country with this one as a junior partner. Thank you very much. Obama came into office in 2009. He benefited from an impulse to peace that led to his rapid anointment with the Nobel Prize. But he had promised, and in the end provided, a torture-free war on terror instead. Debatably, but fascinatingly, Obama quieted opposition, even when critics alleged that it was far simpler to comply with the humanizing laws of war than under George W. Bush, when you capture no one, as Obama did, and kill them by drone attack or special forces raids instead. And yet, the New York Times observed just the other day that it worked. Many supporters of Obama's government and the United States went along. They accepted a moral bargain that the more compliance with the laws of war there was, feigned or real, the more immune the war would look from close scrutiny, even when some of those same critics denounce the very latitudinarian claims of self-defense under international law under Obama that made the war increasingly expansive in time and enduring, expansive in space and enduring in time. Well, the comparison with today is stark. I don't think anyone can doubt now, Israelis least of all, that the reverse has occurred due to the Gaza war. Even as Israel invoked dual-use doctrine, complained about human shields, and relaxed its rules of engagement and worse, its politicians, some of them, and many lawyers in the military profess themselves frustrated that the search for legitimation through law wasn't working. And that was because of the gravity and scope of the violation, the kind of attention that Israel's war did get, and also because, no doubt, of an intentional political strategy to delegitimate the war or the state or both through casting harsh light on the brutality in Gaza. It's a momentous fact, I think. The point of the law in theory is to permit and prohibit. But its most potent role in a domain where generally there's mostly self-enforcement by states of standards they interpret themselves, which means little or no enforcement of the laws of war. The potent role of these laws is in the domain of legitimation. Gaza tops the list now of conflicts in which a focus on brutality of various kinds sapped the moral credibility of the enterprise. As such, the war or the state or both, in the eyes of literally millions, probably billions. I agree here then, at least here, with Michael Walzer's old observation about an earlier episode of bombardment and counterinsurgency. The war cannot be won, Walzer wrote of the Vietnam War, because the only available strategy was a war against civilians. The war against them is an unjust struggle that can only be carried on unjustly. To which I want to add that dramatizing that inhumanity in 2023 through 2025 convinced a global audience that the war was unjust, possibly that the state was unjust, and changed the minds of millions of people on those very points. Now, the discourse around genocide in our time, I think, buttresses such conclusions. Of course, that crime's defined in the Genocide Convention as only adjacent to the laws of war because its prohibitions apply as much to peacetime. And even in a war, the possibility of genocide implicates not just the fate of civilians, but why combatants are being legally targeted and the spirit in which they're being killed. But for our purposes, those legalisms aside, I think the debate on genocide of our time, which really not a debate, one side stating it was happening as a matter of fact, the other incredulous, I think undeniably abetted the general concern with civilian death, aid and food denial in sapping the Gaza war and the state conducting it of legitimation. It's certainly true that there must have been some out there concerned as a matter of legal principle with whether genocide was or wasn't occurring according to the letter of the law. But more were playing out a strategy of turning to law as politics. And we can see this clearly in South Africa's provisional measures litigation at the International Court of Justice, which reflected a jurisdictional accident that this one venue interpreting this one treaty could provide any kind of immediate comment in the midst of an emergency compared to self-enforcement, meaning nothing, or the International Criminal Court pursuing any charges, which would take years, no matter where the ICJ does end up, again, in years from now, when it's time for a definitive judgment rolls around. Indeed, the provisional measures decision of January 26, 2024, I think, spiked an unusual level of enthusiasm out there that mobilizing around international law can indeed make an enormous difference to the legitimacy of a war. But if that's so, it's not because of any immediate effect of the ruling, as because the stakes of the debate around it for the legitimacy of the war and the state conducting it were so high. And it was most pivotal, obviously, that the accused state, Israel, bases its own legitimacy on a prior genocide to the point its defenders could disavow the moral significance of the charge only with very great difficulty. Okay, so this brings me to the second class of effects. Was this war nonetheless perpetuated in any way by the laws of war, by our focus on them, by their near monopolization of the focal point of public attention on a global scale? After all, if a war does end, it shouldn't matter much whether those who succeed in ending it directly show that it's unjust or illegal, or merely show that the conduct of hostilities are. Waltzer's point was that often how wars are fought and debates about that are really referenda on whether they were or are justified. And the question is, can they be perpetuated even so? And it's a little disturbing in this regard, but I think fascinating that in the heat of the conflict, its earliest months and year, American officials openly urged their Israeli counterparts to fight more humanely, not because it was right, but for the sake of the legitimation and the perpetuation that doing so would bring. That was the lesson these American officials, whose words you see on the slide, had learned after 9/11. Don't fight as brutally, and you can fight your war as long as you like. Wouldn't Israel want to take that lesson on board? Did it? Well, that's going to be controversial, obviously. For all the perpetual long-term consequences of the very real delegitimation of the war and of Israel alike, it does appear to me that Israel did adjust its conduct of hostilities somewhat in light of the short-term heat of opprobrium over how it was fighting. I don't want to assert this strongly because counting death and injury is hard, and a full military history of Gaza is something we lack. But it certainly appears to be the case that the Gaza war was characterized by decreasing violence over time. The first 4 months of the bombardment were the worst, with nearly half of the overall death toll so far incurred then. And the subsequent era, however excessive, was at a decelerated pace in comparison. That shift happened, just if you're interested, well before the ICJ rendered any opinion. Now, we don't know the future. Gaza, amid ceasefire, remains a horrifying wasteland. But for all we know, we may have lived through another episode in what Israelis and non-Israelis alike have come to call mowing the lawn, an occasional outburst of increased violence amid steady state enmity that may itself qualify as a larger war over decades. So this is the principal reason we can helpfully distinguish between what I called delegitimation before and perpetuation. The laws of war could allow for a blow to the reputation of a state without necessarily arresting its fighting, or may even have allowed its more humane continuation relatively indefinitely. Sadly, I think, delegitimation of a war amid its perpetuation is another outcome of our Gaza experience on the global stage, and this result doesn't appear set to change soon. Finally, let me turn to my last category of effect. Call it what you want. Were there and are there alternatives to what we've done and are doing? Do the laws of war displace anything, distract us from it, or postpone our consideration of it. Even if you think, and I do, to be very honest, that there was little recourse so far to other political possibilities in the face of the Gaza war, it's always incumbent on us to ask, were there ones we missed? Are there alternative possibilities now? So let me run through those quickly. Start within the law. There was next to no serious discussion, ever, of what exact rights to self-defense do states have when they cite armed attacks in justification of military responses. The most obvious legal casualty of our era of humanizing the war through a new jus in bello has always been the jus ad bellum, and the same has been true in the Gaza war. I think this aphasia has been the single biggest missed opportunity if we care about the law in the Gaza scenario. I can't say that more emphasis in public on when and how far and for how long states enjoy the right to resort to force at all would make the world better, but it might. And we know the world is terrible in its absence, even since the problem of how wars are fought began to predominate our debates just a few decades ago. Then there's the galling irony that it was left not to Joe Biden and his transatlantic partners to reach a ceasefire, faulty as it has been, and fictitious in many ways. It was left to Donald Trump. I haven't talked at all, don't have time, about how the Gaza war has figured in the domestic politics of various places, including potentially helping bring Trump to power again. That's a big topic for Americans and for anyone who cares about the future of its Democratic Party. But we can speculate, for the sake of everywhere else in Gaza itself, about whether a critical error was made in so prioritizing the cleanliness of Israel's self-defense for several years that Biden and his team missed chances to make a ceasefire themselves. Then we should turn the critical tables on ourselves. It was palpably clear in the midst of the atrocious campaign that the nub of Western policy involved a vision of regional order, what I would dub a little impolitely, a theology of normalization. Certainly for American diplomats and policymakers such as Antony Blinken, pictured here among Israelis and Saudis, or Brett McGurk, whatever was objectionable about Gaza was so primarily because it threatened an Israeli-Saudi deal that would allow the degradation of Iranian power in the region. Yes, there would need to be some attention to the fate of Palestine, such figures assumed. But it was always going to be hostage. It was hostage in 2023 and 2024 to what Saudis would require and Israelis tolerate in order to continue towards their pact to confront Iran. Now, debatable as that vision may have been on its own terms in 2023 and after, with liberal internationalists effectively taking on board the agenda of the Abraham Accords of Trump's first term, it's significant that they did connect their concern for the moderation of the Gaza war to a broader political vision, this regional anti-Iranian one. And Israel's successes in the assault on Hezbollah in Lebanon in 2023-4 and the fall of Bashar al-Assad in Syria in 2025, alongside the decimation of so much of Hamas's leadership and rank and file. And then after Trump returned, the 12-day war against Iran itself in 2025, that meant a great many could look with glowing approval on the prospect of a regional power shift. Gaza was sad, but the setback for Iran was stupendous. Now, in contrast, those of us who focalized on the brutal violence in Gaza had very little to say about any of these matters, generally passing over them in silence, failing to integrate a focus on brutality and a broader one about regional order did we have another proposal, assuming we didn't favor Iranian power? If so, nothing was said about it. I think this was a grievous mistake because this view leaves itself open to the charge that it's naive. It missed the point of what the epic struggle for regional mastery was really about. Now, things look different today after the outright failure of the Israeli-American attempt at regime change in Iran. But the point stands, I think, about what got displaced or disregarded amid otherwise honorable concern with the morality and law of wartime violence. Lastly, let me cite the worst casualty of the era of humanizing war, appropriate for this lecture, which is quite simply peace projects and movements. It's easy to be facile about this. We can legitimately ask, though, where the peace is for Gaza and complain once again that it was left to Trump to parody its agent with his peace board, with no powerful alternative on offer. That's where we are, and I think we have to own that in the absence of peace movements in the age of making war more humane, we have to live with the results or find a better one. It suggests the indispensability of constant pressure and plans for political alternatives, which have been condemned so far, in my judgment, to be abstract or marginal. Some examples you see, and we can't leave them there. Well, it's time to conclude. It may be that the era of even minimal consensus around making war humane, at least paying lip service to the cause, is ending. The best evidence for this, alas, is the embarrassing and sulfurous American defense, or as he would prefer, War Secretary, Mr. Pete Hegseth. He polemicized precisely in his earlier career against making war humane in his book. And in office, he's pursued a vision of effective killing, lethality maxing, as one government X account shamefully described it. But I wouldn't get ahead of ourselves. A broader mainstream in the US military, and certainly in the UK military, fully accepts the dictates of the laws of war, of course, once it's been interpreted. True, others are attempting to follow Israel and accepting them, but loosening their constraints. There's a school of thought in the American military saying that large-scale combat operations of a conventional war are coming, and the rules just have to be made more tractable in response. But in spite of these facts, I think the change in our conscience, really, and in expectations that millions, if not billions of people have around war remain. Humanitarian expectations for the conduct of hostilities are deeply ingrained, and I do not think can be undone in a day or a year or a decade. And that means we do have to justify our own focus and priority when such events as Gaza break out and continue. We have to continue to decide whether we privilege how humane our wars are, whether they're humane enough yet. And I have questioned whether our priorities are off. Today, for all the genuine virtues of the cause, because I'm anxious about its neglected vices. One professor and Palestinian activist, Nora Erekat, has written that the only real issue is this: how does law make a political difference compared to the other alternatives available? The law is the sail, she writes in an interesting analogy or metaphor in her book. Where you go is the wind, and that wind is politics and power. If law improves outcomes, she says forthrightly, it should be embraced. If not, not. Stow the sail when it isn't taking you in a good direction. Hoist it when it might, and Professor Aricot adds, stitch a new sail when possible. But there's this question. Is dramatizing infractions of the laws of war the right wind to catch in the first place? And what if you are becalmed as oppression and violence continue? Humanitarian rules, I just want to be very clear in saying, are a good thing on their own. If enough people care about them, including the possibility of a genocide, a dramatization of their violation can even, we know, function as an anti-war politics by other means. We've seen it. But the solutions such humanitarianism provides politically are slight to date. These rules reflect a minimal ethics in a tragic world. They offer no promise in themselves for anything better as cycles of vengeful rage continue as far into the future as we can see. So for such reason, and with all due respect, I would embellish the analogy. If law is a sail, sometimes you need to build a political motor for your boat to overcome the prevailing winds. And of course, you have to know where you are going. What is the just peace that would concretely give us an alternative to ongoing physical violence and legal strife? Perhaps that goal is what we lack. Thank you very much.
But I just want to say a few words of thanks. Putting an event like this together takes a significant amount of work. And so I would like to say thank you first and foremost to the exam schools for hosting us in such a magnificent location. A huge thanks to Rebecca Freeman for organising the event and doing so much work behind the scenes, and to Bev Cousins and her team. They have done a massive amount of work to ensure that this has happened, to arranging travel, to making sure we're all here on time for our sound check, even making sure that our HUDs are on correctly. And I would like to extend our thanks to the Senior Proctor, Professor Andrew Farmery, the Bedell for joining us today, and to the Pro-Vice-Chancellor, Professor Jennifer Payne, for opening the proceedings this evening. This is the Department's principal annual guest lecture in the field of international relations, the University's principal annual guest lecture, and the first Cyril Foster lecture took place back in 1960. The focus of the bequest we received from Cyril Foster was to promote peace, hence Sam's talk, and we are very proud in the department of the success of this lecture series. But this lecture series is only possible because of the work of colleagues and the careful thought and intellectual curation that goes into the preparation of this lecture. And so I would also like to offer my sincere thanks to the Cyril Foster Committee and to my colleague, Professor Edward Keane, who is responsible for the organisation of the lecture. And of course, this leads me to thank our speaker, Professor Samuel Moyn. What a wonderful talk and discussion. How apposite it is in the current context that we gather here to consider the politics of international law. We have returned to a period of heightened conflict and heightened tensions, and I don't remember a period in my lifetime when the potential for global conflict was so great. But if anything, I think that this just reinforces the need for the Cyril Foster Lecture and to have a space and a venue to discuss a better understanding of the nations of the world. So thank you, Professor Moyn, for what I thought was very thought-provoking, challenging, and timely discussion. And so finally, my thanks to all of you, our audience. What a fantastic turnout this evening for coming today and for patiently waiting for me to finish. And to draw this lecture to a close, I would just like to finish by inviting you all to our drinks reception. So please let us finish by thanking Professor Moyn once again and joining us for a drink across the way to continue discussions.